there would have been steps I could have taken to, I guess, lessen the consequences of it. Maybe steps I could have taken to get more help back then, things like that.
Like what help?
Addressing why I was driving and drinking. You know, the types of programs I'm in now, that kind of stuff.
Okay. So you knew you had a right to an attorney. You didn't seek one back then because you felt you were guilty, but also you're saying now with what you know, 20 years later, I think I have a better idea of what attorneys can provide better than I did back then.
Yeah.
Okay. Do you remember what you thought about what attorneys did back then?
I mean, I knew attorneys. I mean, I knew that an attorney would, like, I don't know, quote unquote, fight for you, or, you know, obviously the attorneys understand the laws and how the court system works. You know, all that all works together.
Okay. So back then, did you know that there was a presumption of innocence? Is that term is sometimes used?
Well, I'm sure I had heard plenty of times innocent until proven guilty. But in my mind, back then, the until proven guilty was, you know, the breathalyzer that night.
Because the breathalyzer result made you think, was one of the things that made you think you were guilty.
Yep.
Okay. And did you know that you had the right to testify or call witnesses if you did have a trial? Like you could put on your own.
I guess I can't answer that honestly. Back then, I don't know if I would have ever realized that a DWI goes to a jury trial. Like, honestly, I thought it was just something that was between the prosecutor, the defendant, and the judge. I didn't even realize that that was so. Again, like I said, I was naive about the system.
Did you get jail back then?
No.
Were you told it was possible to get jail?
Yes.
Were you told it was possible to get jail if you didn't accept a plea bargain?
Yes.
And that was part of your consideration as to why you entered the plea bargain?
Yes.
Okay. Gonna show you a document.
Yeah, okay. Yeah.
I'm gonna show you this document, let you handle it, and I'm gonna ask you about it. Do you recognize that document?
I mean, I can read it and know what it is. I'm not going to say that, yeah, I remember seeing this, but
What is it?
I'm sure it says it's an affidavit in support of motion to exclude evidence of prior convictions from sentencing.
Is that the motion Attorney Anderson originally submitted on March 13th? The unsigned one?
It's not the motion.
I'm sorry, the affidavit.
Thank you.
Yeah.
And he had shown that to you before he filed it?
Is this the one, Bruce, is this the one that,
You can't ask him questions.
oh,
Just
yeah.
answer
Your Honor,
to
I'm
that.
going to object to the unsigned one because I believe the filed document was filed on March 18th, included corrections and additional and different statements, things that were crossed out and so on.
It was definitely amended. Where are you going with this?
This is a filed document. This is document 26 in the case.
I do have that document pulled up. I'm going to overrule to the extent that I'm going to provide instruction that just answer what you know. You don't know, you don't know.
Okay,
Judge, could she be provided with a copy of the other file?
I will be providing that later. This is my questioning, not Attorney Anderson's.
She will,
Well,
I will make sure that she has copies of both. And I believe the question was simply, did you review this prior to it being filed?
Yes, this unsigned one before the edits.
I don't know.
I don't know what the relevance of unsigned document is.
You filed it.
I did that.
I'm going to take it for what it is. She answered, she's unsure.
Okay, so you're not sure if you've reviewed that document. I'm going to hand you another document now. I want you to hang on to that one up there. You recognize that one?
Yes,
What is that?
this is the one I signed.
Why does the signed one have all those pencil edits and the unsigned one does not?
I don't know.
Did you know that Attorney Anderson had filed that unsigned one?
I knew that he wanted to get one filed.
Okay. I'm going to show you, or let me ask you this. The hearing where you had the plea colloquy with the judge way back in the early 2000s on the OWI, who was the judge?
Objection assumes a fact, not an evidence.
I don't know.
What is the fact, non evidence?
You can, if there is an objection, Ms. Almandinger, just wait until I give a response as to whether or not you have to answer. I understand you're nervous right now, but you objected facts not into evidence, and your question was what facts are not into evidence?
She's not testified that there was an actual plea colloquy. In fact, I believe she said there wasn't what's known as a colloquy. I didn't use that exact word, but the question said at the time she had the plea colloquy.
I'm going to sustain, and just on the basis, I'm going to guess foundation.
You had said when you were in direct examination with your attorney, you were in front of the judge at some point for the plea and sentencing for the OWI, correct?
I believe so.
You don't remember?
And for the record, I'm just going to say this was from Minnesota, so it is a DWI in Minnesota, but in Wisconsin, they are OWIs. And so Mr. Schmidt is kind of interchanging them simply because Wisconsin uses OWI, not DWI. So you can just infer them as the same.
Okay.
Okay.
Do you remember seeing a judge at all?
I believe that I think I did see a judge after talking to the prosecuting attorney.
But do you have any memory of the interaction with the judge?
I have a memory of standing at a podium and the judge asking what I pled, or I guess I'm assuming it was the judge asking what I pled, and I pled guilty, and then the prosecutor agreed to it.
You say you assume it was the judge. Why are you only assuming it's a judge?
Well, because I was in a courtroom and there was the person sitting kind of like this, and
For the record, Ms. Almandinger has pointed to the court's bench.
Were they in robes?
I would imagine you're asking me a bunch of details about that long ago. I mean, yes, I would say it was a judge.
Okay. Do you remember anything the judge said?
Like I just said, he asked what I pled, and I pled guilty. And then he asked the prosecutor if that was acceptable. I believe the prosecutor said something about accepting it, that we had worked out a plea.
Is the only thing he asked you how you pled?
Yes,
He didn't ask any other questions the whole time.
yes.
Did he say what your sentence was?
I believe the prosecutor is the one that told me that.
The judge didn't pronounce any sentence. The prosecutor said what it was.
You can take your time and think about it.
All right, let's talk about that. This second portion of the hearing picked up right where the first left off, with more testimony from Rebecca Almandinger and deeper probing from both sides. And while it remained a calm proceeding, things got a little murky as the state dug into the timeline and documentation around her original 2005 guilty plea. Now, to give credit where it's due, Almandinger stayed fairly composed under questioning, even when she seemed unsure or confused. She didn't get flustered, she just kept repeating what she remembered, or more often, what she didn't. And honestly, that might have worked in her favor. It felt genuine, not evasive. District Attorney Kevin Schmidt continued his line of questioning by pressing her on the specific rights she didn't understand back then. She acknowledged knowing, at least vaguely, that people had the right to an attorney, but admitted she didn't grasp what that actually meant for her case. She described how her upbringing made her believe that if you were in trouble, you simply dealt with the consequences. That mindset, combined with a lack of legal knowledge, seems to have influenced her decision to plead guilty without counsel. But when Schmidt started getting into whether she thought attorneys fought for you, or whether she knew about jury trials or presumption of innocence, her answers became a bit hazier. Not evasive, just understandably fuzzy given the 20-year gap. One thing that did stand out was the introduction of conflicting documents, an unsigned affidavit with no edits, and a signed one full of pencil corrections. That moment was a bit clunky. Almandinger wasn't sure whether she reviewed the original before it was filed, and it seemed like Attorney Anderson may have filed the earlier version without her final review. It didn't look malicious, just a procedural misstep, but it gave the DA an opening to chip away at the credibility of the defense's preparation. Judge Mogen remained patient and even-handed. She kept things on track, sustained and overruled appropriately, and made sure Almandinger wasn't overwhelmed by the back and forth. A small but important moment came when the DA asked who the judge was in the original 2005 case, and Almandinger couldn't name them or recall anything substantial about the colloquy. She remembered standing at a podium, saying guilty, and the prosecutor basically taking it from there. Her description, vague as it was, helped paint a picture of a defendant who may not have had a full understanding of what was going on. Again, no fireworks, but for a motion like this, the devil is in the details. All in all, the courtroom atmosphere remained respectful, even as both sides pushed hard to frame Almandinger's understanding or lack thereof in ways that suited their arguments. The defense leaned into her naivete and lack of legal exposure. The prosecution tried to show that while she may have been inexperienced, she still knew enough to make a knowing choice. It's a subtle distinction, but one that might make all the difference in whether the judge believes a manifest injustice occurred. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.